May I please, Your Lordship?
My Lord,
My learned friend has already completed his part.
no,
Mr. But the council,
if I am not wrong, my Lord, yesterday when the matter was closed, the council appearing for the examining body, that is the commission, was on his legs, and he has not yet completed, and he is to start. This is what
he requested me. He requested me that he will legs in foot number 1.
From which we have to resume. My Lord, yesterday I have also brought to your Lordship's notice the fact that there is no select list prepared whereby any of the persons who participated in the selection process has been declared as a selected candidate or has been shortlisted as a candidate to go for further course of selection. So in that context, my Lord, we have raised our preliminary objection. We have filed our objection to the IA filed for intervention.
And the main matter itself.
Yes.
So he was arguing.
Yes.
Anyway, so you have completed your stand.
Yes. He has completed.
I have completed mine, and your Lordship.
Yes, start. If he is not there, I can't wait.
Yes, Marat. Yes, Marat. I am starting.
I can't wait for the last. Yes. Is not supposed to wait.
Marat, he also requested me that you start, and in the meantime he will come.
Yes.
Marat, I am for the interveners.
Yes.
Marat,
sit down.
Yes.
Sit down.
What I have understood.
Is over now.
Yes. Marat, what I have understood from his argument. Marat, he has argued before your Lordship.
He has come.
Yes. Now they are holding brief for you. Perhaps you are the person who have to come to their as a savior. But yes.
Yesterday, my Lord.
Yes.
2 points.
Now they have argued the points now. Yes, what are the points you have understood? Just tell me so that I will be able to understand your case so that effective hearing takes place.
My Lord.
He says
Yes.
the preliminary examination ought to have been held.
Yes.
If it is more than 1:5.
Yes.
That is his first ground.
Yes.
Is it not? That is your first ground.
My Lord, that is my first ground.
Yeah.
With a addition, my Lord, with a addition that the language employed in that particular clause is the total number of posts, and posts as is available in the advertised are of 8 categories under the marginal heading of post. One of such post is Hindi teacher. There, that particular sentence doesn't qualify category wise. I mean to say, the language used in page 25, 1 second, you Lordship kindly see.
You have said that. I have understood also. What you say, if total number of posts,
Post, not category wise.
not category wise, total number of applicants. That is the rule. Is
Yes, that is what.
Unless you want to confuse me more.
No.
Yeah, that is it.
Over and above, the other stipulation which is just following that particular clause is that how that main written examination will be held and how much of candidates will be sent up to appear at the main written examination. There the question of category wise will come. So unless that preliminary examination is held,
That will not be known at all.
such a contingency will not. Yes. That to this addition, my Lord, you also proceed.
This is your first ground.
Yes.
Your second ground, just repeat.
Yes. Second ground,
Bilingual.
bilingual. Second lingual is bilingual.
Third ground.
Third ground, my Lord, when a particular procedure is prescribed, that has to be followed in the very same manner or different pattern. Going with the settled principle of law has been decided.
In other words, these are the two contentions.
Yes.
What is prescribed here ought to have been followed.
Ought to have been
part of one only.
Yes. And my Lord, and my Lord, the holding of written examination, by allowing all the candidates in the fray violates also the conditions available in the advertisement itself.
Correct. That is the first round, preliminary examination.
That is bypassing of the preliminary examination. Second, my Lord, allowing rock stock barrel. Whoever made his candidature without complying with 5 times requirement. Again, my lord, for allowing the candidates to sit at the main written examination, they have prescribed 5 times of the persons who will qualify in the preliminary will only be sent to the main written examination category wise. That means as against 80 posts available under the SCBC category notified, or as against 60 posts advertised under the ST category, only 300 candidates belonging to those categories can be sent up for appearing at the written examination. What they did is, the entire 4,493 candidates have been allowed to sit at the written examination, which again violates one of the conditions available in the advertisement, that amounts to changing the rule of the game after the game is played. That is what my submission is. Sorry, my lord. One more addition. Here in the present case, the advertisement being composite in respect of 8 categories of post, and all these plan of examination being one and the same applicable for all. By holding the preliminary examination in respect of 4 categories of posts and not holding for the category of Hindi, even if it qualifies the very same test, amounts to violation of Article 14 and 16.
These things you just write down.
Yes.
Sit here, give them.
Yes, my lord, I'll provide.
I just give that.
Yes, my lord, I'll provide.
Becomes easy for me.
Yes, my lord, I'll provide.
Now only you have to give.
Yes, my lord, I'll.
Yes, sir.
So, my lord, coming to the first point, madam.
Give paper to brother. Yeah.
My lord, I beg apology because my handwriting may not be legible for your lordships.
My handwriting is not legible to myself. Every time after I became judge, every time my banker used to return the checks saying signature is not matching. Oh, I said I have to sign every day hundreds of pages. Naturally, my hand will shake. And therefore, signature is very difficult. I used to call them. I used to sign in front. Sometimes I will ask my gunman to shoot, not shooting me, shoot a picture of me signing the check and sending that also. So that check I get passed.
My lord, the same treatment also we are facing from our bankers. Okay.
Yes.
So, yesterday, my lord, while advancing my argument on the 3 points, out of the 3 points, my lord, I had made only one. But just to, in nutshell, my lord, 1 second I may be permitted.
Yes.
Lordship may come to page number 14, the advertisement, annexure 1.
Annexure what?
The advertisement, my lord, that is 2210.
Go to annexure 1, page 24.
Yes,
24.
page note 14, my lord.
14.
Yes, ma'am.
Ah.
Page note 14.
How many number of vacancies notified?
My lord, that figure is also there, my lord.
Yes, right.
711.
Number of vacancies notified.
For Hindi teacher, my lord, it is 711.
For Hindi teacher, but totally?
My total is, my lord, 6025, my lord.
Total under Hindi teacher category is 711. Categories, further categories, you also kindly come to page 16. The table is there.
No, this is a appointment in respect of many other languages also, subjects also.
Yes.
But challenge is so far as Hindi teacher.
So here the clause 4. Clause 4 may be seen.
Clause 4 at page
16.
Not at 16. 4.
Hindi teacher is, you also kindly mark at the top, name of the post. Serial number 4, Hindi teacher. Category wise vacancies, they have subdivided different categories. You'll also kindly extreme right column, that is 711, out of which 235 are women. Here in each category, there are women breakup was also given. Okay.
So whole case relates to Hindi teacher.
Hindi teacher.
Rest of the candidates you are not concerned with that.
You'll also kindly see. Kindly mark page 16. Serial number 1, 2, 3, 1, 2, 3, they have held the preliminary examination.
For 4 they have not.
For 4 they have not.
4 to 8.
4 to 8 they have not.
4 they have not. But so far as 6 and 6, just a minute. So far as 6, 7 and 8 are concerned, they don't qualify.
because the requirement was where it is 1:5, the number of the applications, valid application received is 5 times the total number of posts. But here the emphasis is here on the post. That is why I pointed out the marginal area post is Hindi teacher, not this category. 5 times of the total number of posts of this Hindi teacher, then they should have gone through this preliminary examination and all. You may kindly bear in mind that in respect of the first 3 categories, they have held that preliminary examination, and a common examination is held for the purpose. Had this
Brother, give the point.
Had this preliminary examination been also adopted in case of Hindi teacher, then the very same examination conducted by them in respect of other 2, we were allowed to sit at.
Yes. Now, what happened to rest of the posts? Whether appointment is going on, that is stalled.
It is going on.
It's going.
It's only in respect, we are on the question of Hindi teacher only.
Hindi teachers, no? Preliminary examination is held in respect of 1, 2, and 3.
And your lordship may kindly
One
see.
second.
Yes,
Am I right?
Yes, your lordship is right.
1 second. 5, 6, 7, 8. No preliminary examination held. There was no need also.
The other, just a minute, the other posts did not qualify the test. The test was the number of valid applications are 5 times in number.
In other words, their number fell short of
10 below.
Therefore, no question of preliminary examination.
Excepting Hindi teacher, where we are making up the
So then 1:5.
Yes.
Okay.
Excepting here, so we could have been accommodated along with the other 3 for which they have held the preliminary examination, which they didn't, deviating the rule.
Once. Sometimes our mic should take rest also.
Well, so far as my mic is concerned, I am switching it off. Your lordship may.
Then we need silence, sir.
Mine.
In other words, less than 1:5. These
Yes.
Other 4 categories.
Yes, my lord.
Therefore, question of holding examination, preliminary examination.
Didn't arise.
is not arise.
Didn't arise.
That question arises. That question arose in respect of 1, 2, 3, 4. For 1, 2, 3 they did. For 4 they didn't. That also is discriminatory and arbitrary.
Yes, that is my contention. Page 65 may kindly be seen.
Got
Page 65, may I draw your lordship's attention to page 65 once again?
65.
Yes, ma'am. Annex 2.
Yes.
That is their own admission as per the notice issued by the Staff Selection Commission.
They have said 1, 2, 3, 4.
Yes. TGT Arts, TGT ODIA, TGT Science and PCM, TGT Science PCM. For these 4 categories, they have held the preliminary examination. For this, the Hindi teacher, they didn't. That they admitted here. We have challenged this order. This Annex 2 is under challenge before your lordships. On the ground of that violation of Article 14 and 16.
Come to page 16.
My lord, page
To page 16.
60.
16.
Sorry, 16.
See that 1, 2, 3.
My lord.
TGT Arts, TGT Science,
Yes, my lord.
TGT Science, CBZ.
Exactly.
But come to page 65.
My lord, TGT ODIA is not part of this advertisement. However, it was a separate advertisement, but they conducted the examination. But in this advertisement, they have not.
Yeah.
That was issued by way of a corrigendum subsequently.
The TGT ODIA was also added.
Subsequently.
When it was added?
My lord.
2/1/2025.
2/1/2025.
My lord, may I be permitted to answer, my lord, because
Yes,
yes,
yes.
No.
I think
It is your lord.
I only asked you.
Your lordship permitted. Your lordship permitted. My lord, I am.
No.
Yes.
Well, may I be permitted 1 second, well,
Yes.
they should take your lordship to the first annexure 1, my lord.
Annexure.
Only with limited points, my lord, I will just keep the, because the entire thing, factually, my lord, it has already been presented. So I'll just.
On facts, no dispute.
No. My lord, annexure 1, advertisement, page note 14. My lord, being the recruiting agency, the Odisha Staff Selection Commission, after receiving the requisition from the concerned administrative department or the appointing authority, my lord.
You notify recruitments.
So, my lord, 1A,
1 second.
the recruitment, appointment and condition of service shall be guided by School and Mass Education Department Resolution number 24570 dated 30th September 2024 and Odisha Staff Selection Commission Rule 1993 and as amended. My lord,
1 second. So Staff Selection Commission Rules 1993 are the position, they are the legal regime. That decides
yes, ma'am.
what should be done, what should not.
That is the procedure, how it is to be followed.
Okay.
And
Do you have copy of the rules?
my lord, in fact, my lord, because these things, my lord, what it has been actually advanced yesterday, my lord, those points were not in the pleading. And later on, my lord, it has been introduced some points
Yes.
in the form of rejoinder. So just to clarify that particular position, my lord, though in shape of an additional affidavit, I have prepared it. I am just serving a copy of that. But I am
Copy
relying
on them also.
yes, sir. But I am relying only on 2 documents.
Yes.
One is the resolution that is 30th September 2024, which has been referred to, of the School Mass Education Department, and the other one is the Staff Selection Rule itself.
Okay.
So these are the 2 things, madam. I'm going to
Share copy with your friends also. Do you have copies now?
Oh,
Or you can get Xerox also from our machine.
so, madam, these are the
If I see the additional affidavit, I need not see the original affidavit.
no, madam. This is
That
only,
also has to be seen.
madam, this is the original affidavit is only with respect to the justification why we did not conduct the preliminary examination.
Correct.
But because one point has been advanced in the rejoinder itself, saying
That we have met here.
the competency is not there. They lacks the OSSC lacks competency to skip that particular procedure of the preliminary examination. To some extent, my lord, I have just tried to clarify that.
Do you have such power at least?
That is what, my lord, I am submitting.
Yes.
Lordship may peruse
Yes.
that first I took your lordship to clause number 1A.
Clause 1A.
1A of the advertisement, that is page note 14, that the recruitment, appointment and condition of service shall be guided by the School Mass Education
School and
Department.
Mass Education Department resolution number so and so.
Yes, madam. That starts with page number 6 to 15 and continue to page number 15, my lord.
Where is that resolution?
My lord, that is in the today's additional affidavit, my lord, just now I provided.
Annexure?
Annexure A by 3, my lord.
A
It
by
starts
3.
with page number 6, my lord, in that additional affidavit. My lord, in the absence of the rule, they have adopted this resolution as the rule, my lord, to conduct this examination. And they have provided the
1 second. The notes only notes. The recruitment advertisement number 4231 is dated 22/10/2024 at Annexure 1 to WP 16409 of 2025 between Rakesh Kumar Parikh and another versus state and others. What? It is covered by Government Resolution number 24570/SME dated 30 September 2024 a copy of which is produced as Annexure A3 in the additional affidavit filed by OP number
3, man.
OP number 3, that is
Staff Selection Commission.
Staff Selection Board.
Staff Selection Commission.
Staff Selection Commission. You wanted me to see this?
Yes. Now, my lord, Lordship may come to page number 8. The clause number 5, my lord, selection procedure. My lord, the selection will be made on the basis of the performance of the candidate in the competitive examination to be conducted by the OSSC. In case the number of applicants are high, OSSC may decide to shortlist the candidate through any standard procedure.
Paragraph 5 of this resolution gives discretion to the Commission to adopt any standard procedure for shortlisting the candidates when number of applicants are high. Okay.
Then, madam,
If page 8 of additional affidavit of ROP3 is false.
next. Lordship may come to clause number 10 of the advertisement.
Clause 10 of the
Clause 10 of the advertisement, that is at page. Yes, madam. Page note 29, ma'am.
of petition,
Yes, ma'am. Oh, sorry, double petition.
your affidavit,
Read petition.
writ petition, go to 29.
That is the advertisement, madam. Towards the last panel, that is page note 29. Internal page 16 of the advertisement. Madam, commission's decision to
Shall be final.
what with respect to what? The decision of the commission in all matters relating to eligibility, acceptance or rejection of the application, penalty for false information, mode of selection, conduct of examinations, allotment of examination centers, and preparation of merit list and post allocation, debarment of indulging in malpractice will be final and binding on the candidates, and no inquiry or correspondence will be entertained in this regard. This is a condition, my lord, which is there in the advertisement, undisputed. My lord, my limited point, my lord, why I am relying upon this particular point in the advertisement section. A point has been conversed in the rejoinder that it is not within the competency of the commission to take a decision and to skip that preliminary examination. Now, my lord, apart from justifying that why the preliminary examination has been skipped in case of in the teachers' recruitment. Now, since this particular point was actually raised, so these are the three additional points, my lord, which I wanted to bring into perception.
No. Commission's decision is final means what? Nobody can go to court.
No, but that is not their intention. That is with respect to the candidates, whether the candidate's decision or candidate's grievance vis-a-vis the commission's decision matter on a particular fact and circumstance.
But the thing which you are now mentioning,
Yes, ma'am.
that does not fit into the parameters of paragraph 10 at all.
That is,
Because you said to the public at large
yes, ma'am.
that we will hold a preliminary examination.
But
If a number of applicants exceeds 1:5.
I'll
I want to know.
No question. Yes.
Only to ascertain whether I am right or wrong, because I have to write the judgment.
Lordship, my question. I beg your pardon.
You agree that you held it out to the public at large?
Yes, my lord, in clause number 4, my lord. In the clause number 4, that is page number 24 In the plan and
No,
pattern of the exam-
why are you citing this paragraph 10?
No,
To
because
counter
my
what?
lord, on the last occasion, my lord, from since yesterday, time and again, my lord, it has been placed before the
Saying that you have no such power at all. Where is the power?
my lord, the discretion of the commission is there, and the power has been to exercise the discretion that has been vested by lord by the competent authority in the resolution that I have the competency to take a decision to shortlist the candidates. Now, if it is required, my submission, my lord, from this stage is that if it is required. Now, my entire endeavor will be for your lordship will to show that after going through this para number 4.1, stage 1 preliminary examination, whether it was required or not, what the decision has been taken by the commission that it is not required, I will just try to listen. Now, for that reason, my lord, repeating the same, my lord, what I had mentioned, my lord, yesterday, lordship may come once again to page number 24, the plan of examination, the preliminary examination. It consists of two.
The senior panel counsel representing the commission admits that at para 10 of the advertisement, discretion is retained with the commission to decide as to whether the preliminary examination should be held or not. And therefore, the first contention is that the commission lacked competence to dispense with the examination of the candidate is unsustainable. That's your contention.
Yes.
Okay. There are 10 of course, there are 10 into bracket. Petition
Well,
page number.
Petition page number, my lord, that is page number 30. Para 10, my lord. This one, it is page number 29, my lord.
Is 29 of the
Now, my lord, my next point to meet that particular problem, whether it is actually 5 times or not.
Can you read para 10, sir, once again?
What's this? Now, the decision of the commission in all matters relating to eligibility,
Eligibility,
acceptance or rejection of
rejection
applications,
of the application or penalty for false mode of selection.
conduct,
That comes in the mode of selection.
the next conduct of examination,
Conduct of examination.
bracket is one adjustment. So, allotment of examination centers and preparation, that is.
Yes.
But my lord, a discretion, since it is vested with the authority, that doesn't mean that my lord, he will arbitrarily exercise. So whether the,
Please repeat.
my lord, a discretion which is vested with the authority, that doesn't mean that my lord, he will arbitrarily exercise. My submission also, my lord, with the same line as that of the counsel of the petitioner, my lord, that it should not be arbitrary. It should be in consonance with the, and it should be in harmony with the other conditions stipulated in the advertisement. That is what, my lord, I'm just trying to show. Now, stage 1 preliminary examination, my lord, that is in objective type, that is in multiple choice question, my lord, that is page number 24. In repetition to my earlier submission, my lord, once again, I may be permitted to read that, my lord.
Yes.
Page number 24, my lord. May I be permitted?
Page number 24, para.
Page number 24, para number 4, plan and pattern of examination. The stage 1 is the preliminary examination,
MCQ.
MCQ, my lord, and what it has been stated that it is qualifying in nature. Preliminary examination will be conducted for such posts where number of valid applications are more than 5 times the advertised vacancies. There is a full stop, my lord, thereafter.
Correct.
Now, my lord, such posts, because my lord, previously it was 8 and later on it was made 9.
No, read full.
My lord, I'm coming to that. My lord, such post. Then, my lord, based on marks obtained in preliminary examination, approximately 5 times the number of the candidate will be shortlisted post-wise and category-wise for appearing in the main written examination. So, my lord, the requisitioning authority, they allowed us to go for conducting one examination and to prepare the select list. The select list will be based upon the main examination. Now to shortlist a candidate, they also provided us the power to go for adopting any kind of method manner for examination. So after receiving the valid applications from the different candidates, then what we have mentioned in our counter manner, original counter, and I had presented it before Lordship manner yesterday, the figures, the different figures, with the Lordship's permission, I may further be permitted.
Para 4, 5, 6.
Para number 4, 5, 13, 14 and 15. Para page number 6, my lord, it is.
Next one. The panel council draws attention of the go to the earlier page 29 draws attention of the board to paragraph 4 of the advertisement at running page 24 of WP. Which contains a table comprising of 3 stages, namely preliminary examination into brackets, objective type, comma, MCQ, bracket complete. Stage 2, main written examination, objective type, MCQ. And stage 3, certificate verification. First off, he loudly reads the contents of remarks column against preliminary examination, that is stage 1.
Yes.
This contention is what is your contention?
My contention is that, my lord, there are 3 sentences in fact, my lord. First one is that it is the preliminary is qualifying in nature. And my lord, the preliminary examination will be in respect of those particular posts where the valid number of applications will be 5 times.
Correct.
More than 5 times, my lord.
Correct.
And the third sentence, my lord, simultaneously, it is to be read, our submission is that, my lord, that is to be read simultaneously, that the aim and the objective of this preliminary examination is to shortlist the candidates so as to send the candidates for the main examination with each category wise and post wise in shape of 1:5. But these are the 3 sentences which are not independent of each other. These are all interlinked with each other in the preliminary examination. Because our motto, our aim to exercise our discretion to go for an additional examination in respect of a particular post is to see that the candidate should be minimum 1:5. That is why
Reduce the zone of consideration.
exactly most of them.
How you want to read remark column 1? You mean to say you need not go by the total number of applicants at all. That's your case.
Now what it has been done, how we have actually read it. Now can I take a little shift to page number 6 of our counter?
Your affidavit.
Yes, first affidavit. Page number, para number 13, my lords. Because as it has already been placed before lordship that with respect to 5 categories of people, we skip this preliminary examination. So, my lord, may I take your lordship to the page number 6?
Where is that affidavit?
My lord, yesterday it was not there. That is why, my lord, I submitted once again, my lord.
Yes, yesterday. Just see, sir, with this, just look into
Opposite but no 3 and 4.
11/7/25 affidavit. সেটাও ইয়েতে ଅଛି হার্ড কপি কোর্ট করছে ଗତକାଲି ଦେଇଥିଲେ ଗତକାଲି ଏଇଠି ହ୍ୟାଣ୍ଡ ଓଭର କରିଥିଲେ
Is there any decision of any High Court or of the Supreme Court which says, where they said we will hold preliminary examination, but they did not hold, then entire recruitment process is vitiated? Direct decision on that?
My lord, my lord, subject to your lordship's acceptance, your lordship may kindly see one paragraph.
Just take that.
Whether it is appropriate or not, your lordship will take the call.
That's it. So according to your, in your
Para 29. Your lordship may kindly see para 29.
1 second, sir. 1 minute. Sure. Just I'll come back to you. Para 29.
Coach. Reference ଅଛି 2012 AR SCW 2403 ବେଦାଙ୍ଗ ତାଲୁକଦାର
Next point, just petitioner's counsel banked upon apex court decision in Vedanga Talukdar versus Saifullah Khan. 2011 LVCC is 85, paragraph 29, to support his contention that there is no power to relax conditions of advertisement in the extant rules, and in any event but the relaxation could not have been right without giving due publicity, and that there is absolutely no justification for going for such a relaxation. But he also tells that the three stages table in the advertisement, more particularly what is stated in the remark column against stage 1. Does not come to the rescue of OP number 3, in as much as the prescription of preliminary examinations is intended to squeeze the zone of consideration when the number of applicants as against the number of vacancies exceeds 1:5 ratio. Correct?
Exactly.
Okay. Whether in the rules, is there any power to you?
With respect to.
Did you share that copy of the judgment with him? Just one.
Yes, yes, yes. I'm
Just look into that paragraph.
Yes.
So that it becomes easy for you to argue.
Well,
We will know our parameters. Mainly see the ruling.
Yes, my lord, I'm giving.
Give that.
Yes, my lord, I'm giving.
The first requirement is you should have power in the rule. The second requirement is that power should be mentioned in the advertisement itself.
Yes.
Then number 3 and 4 are there.
Yes.
Just look it, just for a moment. Just glance it.
My lord, there also, your lords may kindly see para 14. Sorry.
Why do you say sorry? I'm taking not wine, I'm just drinking water. But that cannot be of much relevance.
My lord, subject to lords. My lord, there the advertisement stipulated that
Language.
No, not that language. The candidate has to sign the application form in the very same language where he will ultimately appear at the examination. There the candidate, what the candidate had done, candidate had signed in English, but while appearing at the examination, appeared the examination in Hindi. There the Honorable High Court allowed his read, saying no, since he has appeared at, and the handwriting expert says it is his handwriting, you have to accept that. Honorable Supreme Court said no, when the advertisement said that this has to be complied with. When a person who has put his signature in English, he has to write the question paper in English. Since there is a violation, it cannot be countenanced, and all these judgments were followed, including the judgment of that Nazir Ahmad and Taylor. You will also may kindly see. When a
Procedure is prescribed, that should be followed.
Yes, my lord.
Otherwise, you should not do anything else.
Yes, my lord. You will also make Kerala the judgment where it reiterates that salutary principle and that Babu Varghese, everything, my lord.
Yes.
So, my lord, I have gone through that judgment, my lord. I'm just clarifying whether this particular judgment and the principle decided is distinguishable in this case or not, my lord. So, may I take your lordship to page number 6 of my counter? On the basis of the facts and yes, para number 13, my lord. It was presented with.
Have you got the phone? Yes. Here only. Paragraph number?
Paragraph number 13, page number 6, my lord. It was submitted before lordship that accepting this Hindi post in all the 4 categories, the post for which the preliminary examination was also excluded, for them, my lord, this particular qualification, the criteria was not actually met. Lordship may peruse what is the number of the valid applications we received and what is the decision in respect to those 4 also, my lord. Page number, para number 13.
First counter. Counter affidavit. You're right.
Page number 6, man.
Yes, it is still Page 6.
Yes. So, my lord, the 5 number of the 5 categories of the post which are reflected in the annexure 2, which is impugned before lordship where the preliminary examination has been excluded. These are the 5 categories of the post, Urdu teacher, Telugu teacher, Sanskrit teacher, Hindi teacher, and physical education teacher. Now, the total number of the vacancy, 14, 6, 729, 711, 681. And total number of the valid applications also, we have indicated. My lord, with
As against Sanskrit Hindi teacher 4493.
yes, oh,
Para 13.
yes, my lord. Yes. So, my lord, my first submission, my lord,
Yes.
this particular figure has already been placed before lordship. But why I am again citing this or relying upon this particular para number 13 is to nullify the statement, the allegation against us, my lord, that it is only with respect to the Hindi post. No. My submission, my lord, lordship may peruse and appreciate that total number of the vacancy is 14, vis-a-vis 36 in Urdu teacher post. Yes, it is less than 5. But in Telugu teacher post, my lord, it is 6 vis-a-vis 81. A decision was taken by the commission, my lord, that since only 36 and 81 number of applications are only there.
No, for them there was no need for taking preliminary examination at all.
My lord,
That is his case.
My lord, no, that is not his case, you know, that is our case. Rather, he said that.
No, sir. What he says, the question arises where
More than 5 times.
Ha.
My lord, in that case, my lord,
More than 5 times.
in that case, my lord, Telugu teacher,
Yes.
lordship may peruse, the total number of the vacancies is 6 and the number of applicants is 81.
More than
Correct.
5 times.
Now, my lord, lordship may come to Sanskrit. It is 729.
No, even where what you have stated, number of application is too few to conduct, that itself is wrong.
My lord,
Because
my lord,
6 is to 81.
Yes.
How much it will be?
But-
12 nearly more than about 6 times.
Yes.
Even your
12 times.
Telugu teacher,
12 times.
Telugu teacher, my lord, it is more than about 13 times.
correct,
More than 5 times.
Because
more than 5 times.
Yes.
yes, more than 5 times.
Yes.
Because these numbers, these 36 and 81, which are not before your lordship, rather it has been placed before lordship that they meet that particular category. That is why the decision was taken properly. Because time and again it has been placed. Now that is what I am submitting, that in not in respect of the Hindi, but in respect of Urdu as well as Telugu, where no proceedings are pending before any court of law and the selection procedure at the again, my lord, there also, my lord, the same discretion has been exercised. And in respect of, my lord, I will clarify that, my lord. Again, in respect of, my lord, Sanskrit, it is 729. It is 4,969. It is more than also 5 times. And physical education teacher, my lord, 681. It is 4,674. Apart from this Hindi teacher, then why not, my lord, in the Hindi teacher and other post, why not? Then lordship may come to para number 14.
No, I have not understood your
My
answer.
lord, that is what my submission, my lord. It is not only, there are 9.
Not only Hindi,
No, no.
but other subjects also the same thing you have done.
The same principle which has been followed in respect of Hindi,
Yeah.
the same principle was also followed in respect of other posts also, my lord.
That you could not have done is his case.
My lord, he says, my lord, all along, my lord, he submitted that, my lord, in respect of all the other categories of the post, they fulfilled the criteria. That was below 5 numbers. That is why, my lord, they did not.
That may not be correct.
Madam-
If at all he has said that. But question is, where is the power to you
Madam,
to
then-
dispense with the preliminary examination?
That is what-
That's the simple, the whole jugular vein of the case is that or no.
Now, my lord, come to, my lord,
How to give up bilingual policy?
No, that is what, my lord, we have stated that we have made a comment. We have committed a mistake.
No.
Bilingual. My lord, that is what, my lord, the answer 5, which is under now challenged before the lordship, that notice has been issued by us, admitting that there is a mistake, inadvertent mistake.
Now, what should be the consequence of your admission?
My lord, we have actually, therefore, we have asked for the options for the candidates who want to go for examination.
Now, how that will be? It will not be common level playing ground at all.
My lord, if a lordship will be of that opinion, my lord, it will be for all the persons, my lord. We do not have any objection. We will do it. We will do it, my lord. We are, my lord, whatever it has been done, my lord, we are just placing it before lordship. Then your lordship has taken it, sir.
No, since you have admitted very fairly that mistake has happened,
Mistake has been happened, my lord. We are admitting only with respect to that, my lord, that bilingual, with respect to that pedagogy and evaluation subject, that is 20 marks, my lord, which is an MCQ question.
where have you stated it in your affidavit? Or it's only argument?
My lord, we have admitted, my lord, that is why, my lord, answer 5. Answer 5 is our document, my lord, which is under challenge. On admission that there is a mistake, my lord, this is the follow facts. So there is no requirement of any further affidavit to that, I think. But we have also admitted that.
Your notice dated 17/5/2025 itself says that is your contention.
Yes. And on the basis of the persons, but not limited. Though it is indicated that it is limited only to the persons who have made the grievance, but my lord, we have also given the figure in this case, my lord, that as against the total number of the candidates, my lord, 4493, para number 17, my lord, I am referring. 3,879 candidates appeared in that examination, and 1,620 candidates in terms of financial 5 million, they opted for a re-examination. But if your lordship is of the opinion that it will be in respect of all 3,879, the pedagogy and evaluation mark will be, examination will be there, not having objection. Because we are preparing the examination papers for 1,620, we do not have any problem for preparing the examination for 3,879.
That's so far as second contention is concerned.
Yes, that is
for
what
the first contention. What's your answer?
now, my lord. That is one, my lord, because I could not place it simultaneously. Now I placed it before your lordship that the total number of the valid applications which we have received in para number 13. Now lordship may come to para number 14. That is our justification. Now it is for lordship to appreciate it, my lord. We have done it fairly in a transparent manner, and we have done what we have done, my lord, we have stated. My lord, since a conjoint reading of the entire para number 4, that remark column, my lord, that our intention to go for preliminary examination with respect to preparation of a category-wise, post-wise and category-wise list of 1:5. Our intention is to hold a preliminary examination, lordship may peruse, in respect of this category. The one is Hindi, then Sanskrit, then physical education teacher, my lord. We have given the breakup, my lord. So for the total number of the post in UR category, it is less than 5. SC category, it is less than 5. ST category is less than 5. Only in SCBC category, my lord, it is more than 5. We cannot segregate, my lord, SCBC category to go for a preliminary examination. It can be post-wise, my lord. It cannot be category in respect of the SCBC. Similar in the same, my lord, case of Sanskrit, my lord. The next page we have given. So, my lord, now confining the same, my lord, to the Hindi teacher, my lord. Once again, my submission, my lord. Since the motto of the preliminary examination as per the resolution of the School Mass Education Department, empowering the Staff Selection Commission to go for a shortlisting procedure, and it is also indicated in the plan of examination that to prepare a list to send them for the main examination 1:5. So since we did not have the category-wise persons in 1:5 in respect of these category of the post, but in respect of those category of the post where when 1:5 was there, we conducted the examination. The same examination was required to be followed in respect of all. But once we did not have that particular number, the figure with us, my lord, then in that case, my lord, there was no purpose. That is what, my lord, our submission, that it is exclusively because for this reason that the category-wise 1:5 is not available, excluding one category.
But the prescription of preliminary examination is not dependent upon the category, but it depends upon the numerical strength of the applicants.
That
This is the contention.
My lord, his contention, my lord. My submission, my lord, the sentence what he is actually borrowing from that particular column, my lord, column number 4. My submission, my lord, that number three sentences which are available, those are to be read conjointly, my lord. A decision is to be taken by the commission. At the time of taking a decision, my lord, when by reading the three sentences simultaneously, and that is the reason for which, my lord, with respect to the 4 categories of the post, there is no dispute. There is no case at all.
They should be harmoniously construed, is your version.
My submission, my lord. And my lord, and this has been followed not only in, but there is no any kind of anonymous decision, my lord, with respect to this Hindi teacher persons, because the same principle which has been adopted in respect of other categories of the post, my lord, the principle was also adopted in respect of Hindi. And my lord, in respect of those other posts, my lord, these are on the stage of the document verification and other things, my lord, which are not in board, my lord, and never disputed. and the persons who have already been selected. Now, my lord, this is a question of principle. The principle which we have adopted, my lord, by analyzing the entire procedure of clause number 4, the principle has been adopted in respect of all the 5 posts, not in respect of only one. So, though, my lord, there is a restriction in shape of an interim order, my lord, not to go ahead with this particular in respect of Hindi teacher post, my lord, but with respect to the other post, my lord, since there is no such restriction, and there is also a direction by your lordship in another case that to publish the results, my lord, and we have complied that order. Complying your lordship's order in this recruitment examination with respect to other posts where there is no interim order.
Interim order was modified.
No, that is only with respect to TGT ODIA, my lord. That lordship also modified that order, keeping
Both side argument.
11 posts.
11 number posts. So, my lord, my submission in this case, my lord, I took your lordship to that particular provision of the resolution of the government where we have been empowered in the exercising our discretion for shortlisting. Now, for shortlisting, my lord, we prepared a method and we also quoted the same in our advertisement, but it cannot be read in isolation. Our submission, my lord, when the documents were placed before the commission, at that particular point of time, taking into consideration the total number of the applicants and the applications and category wise, and the objective behind the holding the preliminary examination. Since in respect of these 3 categories, it did not satisfy that particular objective, we actually did not conduct. My lord, that is the only submission in our counter. And we have fairly admitted, my lord, that yes, it was a mistake with respect to non-publishing the question papers, my lord, with respect to pedagogy and evaluation subject in bilingual, my lord. And that is why after receiving the objections, my lord, immediately, within few days, my lord, we responded to that and we have already issued that notification. But it is up to your lordship's decision to that effect, that whether it will be confined only to the persons who have opted or it will be for all, my lord. But my prayer, my lord, in this case, with respect to the decision, so far the preliminary examination is concerned, I pray, my lord, the decision of the commission is correct and there is no illegality or irregularity or malafide in any manner in this case. And my lord, now my last sentence with respect to this argument number 1, that when this is the decision of the Honorable Appellate Court, the lordship so also wanted to me to go through that particular decision in para number 29 and para number 32. The same thing, my lord, it has been reiterated, the observation and the direction. Where there is a prescribed procedure, it is not to be deviated. And in absence of any provision to relax, such type of relaxation cannot be extended. My lord, the manner in which, my lord, the entire examination has been conducted, and particularly the preliminary...
the power to relax available in the rules.
Rules, my lord. My lord, the rule is completely, my lord, the rule says that, my lord, I have to exercise my discretion.
Where is that rule?
My lord, the rule, my lord, what I have submitted before the School Mass Education Department, empowering the School Mass Education, the Commission, Staff Selection Commission, to go for a
rule, 1990 rules or what?
1993 rule, my lord. 1993 rule, my lord, that is with respect to the conducting the examination and other things, my lord.
It is modality.
My lord, it is a modality, my lord. That basically, my lord, because these two things.
Answer whether there is any empowerment in the rule, which
In the resolution that is there.
the resolution it is there. I have seen that.
My lord,
Rule, what is the position?
my lord, my submission, my lord. Since a decision is to be taken by the commission in this respect, in terms of a condition which is available in the advertisement itself at clause number 10.
No, judgment said rule also.
Yes.
There are 29.
Well,
Speaks of rule also.
Yes.
My lord, that I do not dispute, my lord, because I have no authority when my lord to do it go over it. But this particular aspect of availability of a clause number 10 in that particular advertisement itself, whether such a parameter provision was there in that particular advertisement, because, my lord, that is a matter relating to asking for a particular document or an additional status of a particular PWD candidate to justify his status. So, my lord, that particular aspect is something different. Here, my lord, the aspect is completely different. Here, a method has been adopted method, my lord, that has been prescribed in that particular advertisement, it has been strictly implemented. And the authority who has exercised his competency is also available in the particular advertisement itself, my lord. And those conditions which are available in the advertisement, that is not under challenge. And my lord, that is most importantly, my lord, that is not, it has not been applied limiting to the post of Hindi only. I have already explained it, my lord. It has been, my lord, the same notification is annexed 2, that is in respect of all the 5 posts. And I have also given the details of the 5 posts, my lord, that is from para number 13, 14, 15, and 16.
My lord,
Let me answer.
Can I,
He also wants to say, thereafter you can answer.
give a reply to?
No, you will give reply after.
Yes, ma'am.
Yes.
But my respectful submission before your lordship says,
You are for interveners.
yes, I am for the interveners in both the cases. My lord, your lordship may kindly note down the point that so far as the petitioners in both the cases are concerned, they have participated in the selection process without any demur. At no point of time or at no stage they have ever raised any objection, and only after the
When submits, when the petitioner has participated in the recruitment process, now cannot turn around and lay a challenge after fishing without information. Okay. Next.
and my lord, your lordship may kindly see what my learned friend has argued before your lordships. Well, at what stage they have approached this honorable court? Well, when the key answer sheet was published, they knew about their position. Your lordship may kindly see the intervention petition which I have filed in the first application.
The key answer sheet where
On
on which date?
Well, this was published. My lord may kindly see the intervention application filed by the.
No,
my
I
lord,
believe you.
yes, that is in the first case, WPC number 15086 of 2025. And my lord, key answer sheet was published. My lord, on 27/5/2025.
27/5/2025. And the petition is filed on?
My lord, the petition is filed on
17/6.
nine.
17/6.
21
17/6/2025.
21 August.
Sir, 17/6/2025. Well, because they knew about their position.
The first case. Like that. Yes.
So after knowing their position from out of the key answer sheet, well, they have challenged the selection process. And my lord, I have brought a judgment, and your lordship is aware of that judgment, that once you have participated in the selection process, there are catena of judgments on this point.
In support of submissions, it was to service.
And they have, if they have not raised any objection, this is a 3 judges main judgment. That is
Next.
Ashok Kumar.
Next point.
Yes, my lord, my next point is, my lord, his main contention is that rule of game has been changed. My lord, rule of game has been changed by not conducting the preliminary examination or shortlisting. Then he says that so far as pedagogy and evaluation question is concerned, that should have been published or that should have been printed in English and Hindi, but it was only printed in Hindi. These are the 2 basic points he has raised.
Only 2 points.
Only 2 points.
Yes.
My lord, so far as rule of game is concerned, the recent constitution bench judgment in Tej Prakash case, my lord, it has got 2 parts. The first part is relating to eligibility criteria. Eligibility criteria which has been prescribed under the rules or in any government resolution or executive instruction, that cannot be changed. But so far as method or manner of selection is concerned, that strictness will not be applicable. Here, my lord, we are only
Explain something that. In the light of latest decision of the apex court.
yes in the constitution bench.
In that, what is?
That is K.S. Prakash Pathak and others
Says Prakash.
versus Rajasthan High Court and others, reported in 2025, two Supreme Court cases, page 1. My lord, may kindly come to
The adherence to the rule position is confined to eligibility criteria and that for rest of the things,
yes.
relaxation is permissible.
Yes, your lordship may kindly permit me to place paragraph 54 to 59.
Not providing the bilingual facilities does not fit into the eligibility criteria as such, and therefore much cannot be made out from the breach of the requirement of bilingual, breach of bilingual requirement.
Or that preliminary examination. Or your lordship may kindly, your lordship may permit me to place paragraph 54 to 59. The heading is, rule does not apply with equal strictness to steps for selection. As already noticed in section A, a recruitment process inter alia comprises of various steps like inviting applications, scrutiny of applications, rejection of defective applications or elimination of ineligible candidates, conducting examinations, calling for interview or viva's, and preparation of list of successful candidates for appointment. Subject to the rule against arbitrariness, how tests or viva's are to be conducted, what questions are to be put, in what manner evaluation is to be done, whether a shortlisting exercise is needed, are all matters of procedure. Here, my lord, your lordship is dealing with the preliminary examination relating to shortlisting. And preliminary examination, on the basis of the marks secured in preliminary examination, merit list will not be drawn up. Merit list will be drawn up on the basis of main examination and verification. Well, that is contemplated in the resolution itself.
The government resolution itself which states
Yes.
that stage 1, 2, 3.
Yes,
Stage
yes.
1 is preliminary, stage 2 is main examination.
Main examination, but so
Stage
far as
3
the
is
merit.
verification of records.
Yes. Your lordship may kindly see.
Instead of records, it uses the word certificates.
Yes, your lordship may kindly see the advertisement again.
Yeah.
That is.
Because 14 it begins.
No.
Relevant part. Yes.
Well, let me kindly come to clause 8, page 27. Page 27 of that advertisement.
Page 27 is the running page.
Running page 27 of the second case, which my lord has taken up.
Merit per select list.
The merit lists shall be prepared in order of merit post-wise and category-wise, basing on the marks secured by candidates in the main written examination out of 150 marks and found suitable in certificate verification. The select list will be published equal to number of vacancies advertised.
Correct.
So preliminary examination is not a part of the, my lord, so far as selection test is concerned, is not a part for drawing the merit list.
Correct. It only decides the zone of consideration.
Zone of consideration. My lord, how candidates are to be shortlisted. Now you also may kindly come back to that decision, that is paragraph 54, my lord. Para 54. As already noticed in section A, recruitment process inter alia comprises of various steps like inviting applications.
Whatever says so.
Well, I have said.
Arbitrariness, how tests are
Yes. Then you also may kindly come to paragraph 55. To elucidate the above proposition, we shall notice a few instances where the procedure.
Read 54 only.
Yes.
It's one sentence.
Yes.
Whether a shortlisting exercise is needed or
Yes.
all matters of procedure.
Yes. Subject to the rule against arbitrariness, how tests or viva's are to be conducted, what questions are to be put, in what manner evaluation is to be done, whether a shortlisting exercise is needed, are all matters of procedure, which in absence of rule to the contrary, may be devised by the competent authority. But pausing here for a moment, Here, my lord, there is no rules. There is no extent rules. Here only government resolution is there, read with Staff Selection Commission rules 1993, that only provides the modalities. So far as government resolution is concerned, my lord, may kindly see the government resolution dated 39/2024. My lord, my learned friend has given, your lordship may kindly see that. Because in absence of statutory rules or extant rules, this resolution will prevail over the advertisement. And what this resolution says? This resolution says, so far as shortlisting is concerned, your lordship may kindly come to para 5. Selection procedure. The selection will be made on the basis of performance of candidates in the competitive examination to be conducted by the Orissa Staff Selection Commission. In case the numbers of applicants are high, the Orissa Staff Selection Commission may decide to shortlist the candidates through any standard procedure. May. You also may kindly see, it is the discretion of the commission. So this is not a mandatory provision. So far as shortlisting of candidates is concerned, that is not a mandatory. That is not a mandatory one. That is a discretionary one. And here, taking in what my learned friend has argued before your lordships, who appears for the commission, he has stated that not only in respect of Hindi, but also in respect of other subjects where candidates are even in more than one category or less than 5, 1:5, my lord, no preliminary examination has been held. Had it been mandatory, then what my learned friend says that, my lord, dispensation of preliminary examination would have weighed your lordships. Now your lordship may kindly come to para 55. This is relating to procedure. To elucidate the above proposition, we shall notice a few instances where the procedure devised by the recruiting body has been approved by this court. In Santosh Kumar Tripathi versus UP Power Corporation, this court was required to consider whether the rules enabling Service Commission to examine, interview, select and recommend suitable candidates would include power to hold written examination.
It said
this court accepted the High Court's view that power to examine would include holding of written examination. Then para 56. In MP Public Service Commission versus Navneet Kumar Poddar, the question which arose before this court was as to whether in the process of shortlisting, the commission has altered or substituted the criteria or the eligibility of a candidate to be considered for being appointed against the post of presiding officer Labor Court. In that context, it was observed, it may be mentioned at the outset, that whenever applications are invited for recruitment to different posts, certain basic qualifications and criteria are fixed, and the applicants must possess those basic qualifications and criteria before their applications can be entertained for consideration. The selection board at the commission has to decide as to what procedure is to be followed for selecting the best candidates from amongst the applicants. In most of the services, screening test or written test have been introduced to limit the number of candidates who have to be called for interview. Such screening test or written test have been provided in the statutes or prospectus concerned which govern the selection of candidates. But where the selection is to be made only on the basis of interview.
That is not the case here.
That is not the case here. Well, you also may kindly come to para 57. Likewise, in Union of India versus T. Kundaraman, where the eligibility conditions referred to a minimum of 5 years experience, the selection committee was held justified in shortlisting those candidates with more than 7 years experience, having regard to the large number of applicants compared to the vacancies to be filled. The relevant observations are being extracted below.
This is a reverse principle.
Yes. Then
what he argues is,
yes.
See, our question was whether the preliminary examination should be conducted or not.
Yes.
They said we conduct it. That was sought to be challenged. Both said it is perfect.
Yes.
Here is a case
Yes.
where the requirement was preliminary examination, but you have not held it.
Yes.
Where is the parallel to that?
Yes, yes. Your Lordship may kindly come to para 58. These are all relating to procedural aspect. Similarly, in Tridip Kumar Dingal versus State of West Bengal, it was held that shortlisting is permissible on the basis of administrative instruction provided the action is bona fide and reasonable. The relevant observations in the judgments are extracted below. The contention on behalf of the state government that written examination was for shortlisting the candidate and was in the nature of elimination test has no doubt substance in it. In view of the fact, the records disclose that there were about 80 posts of medical technologist and a huge number of candidates, approximately 4,000 applied for appointment. The state authorities had therefore no other option but to screen candidates by holding written examination. It was observed that no recruitment rules were framed in exercise of the power under the proviso to Article 309 of the Constitution, and hence no such action could be taken. In our opinion, however, even in absence of statutory provision, such an action can always be taken on the basis of administrative instruction for the purpose of elimination and shortlisting of huge number of candidates, provided the action is otherwise bona fide and reasonable. Another example is in respect of fixing different cutoffs for different subjects having regard to the relative importance of the subjects and their degree of relevance. These instances make it clear that this court has been lenient in letting recruiting bodies devise an appropriate procedure, I am harping on this, for successfully concluding the recruitment process, provided the procedure adopted has been transparent, non-discriminatory, non-arbitrary, and having a rational nexus to the object sought to be achieved. So my submission before your Lordship is, my Lord, it is borne out from the records that for not conducting the preliminary examination for shortlisting was not in respect of one subject, that is Hindi, that is also in respect of other subject, that is Sanskrit.
But they are not here.
But they are not here. They are not here. And the commission, my Lord, prior to selection was held, a notice was given to them. They did not raise any objection to that notice. My Lord, when notice was given, your Lordship may kindly see, the notice was given on 12/2/2025.
February 25.
12/2/2025.
Swain argues that on 12/2/2025, notice was issued to the notice was published.
Yes.
It was not individual notice. It was published online.
Yes, for all.
Published on the website of the commission as to what will be made in the context, and no objection was filed by the petitioner. First, they have filed the petition only after knowing their position. That is, after the publication of
Key answer sheet.
key answers, and therefore they are stopped from
Yes.
maintaining the petition.
Yes. Then, my Lord, I am conscious of the position that where there is a statutory rule providing a particular procedure, certainly that procedure is to be adopted in that manner, not otherwise.
Here there is no such.
Here there is no extant rules or statutory rules governing the field. Here only the government resolution is there. And the government resolution, well, the expression is may, it is not mandatory. And discretion is given to the commission. Well, I am relying upon another decision.
But what it says,
Well, here, that is state of Uttar Pradesh versus Arunesh Kumar,
Prakash Patak is
2022-18 SCR is 1174, para
21, para 32.
para 32.
what it says.
Well, your Lordship may kindly see para 32. The respondents have also placed reliance on the decision of this court in the case of K. Manjushri Supra. However, in our considered view, the facts of the aforesaid decision are quite different from the present case. A change was introduced for the first time after the entire process was over. Based on the decision made by the full court was the cutoff in K. Manjushri's case.
But it is considered even in
Tejprakash case, and it was held to be good law. Secondly, it is not as if the private respondents were non-suited from participating in the recruitment process. The principle governing changing the rules of game would not have any application when the change is with respect to the selection process, but not the qualification or eligibility. My lord has marked it.
only when it is qualification or eligibility
That cannot be changed.
that cannot be changed. Rest of the things are permissible for change.
Permissible for change. So therefore, in Tejprakash case, it has been categorically held that that strictness will not be applicable where the procedure.
Eligibility and qualification is strict.
Yes.
Rest of the things are relaxable.
Relaxable.
That's your condition.
Yes, my lord, your lordship may kindly permit me to the principle governing changing the rules of game would not have any application when the change is with respect to the selection process, but not the qualification or eligibility. In other words, after the advertisement is made followed by an application by a candidate with further progress, a rule cannot be brought in disqualifying him to participate in the selection process. It is only in such cases the principle aforesaid will have an application, or else it will hamper the power.
The concept of change of the rules of the game is confined to the eligibility and qualification of the candidate.
Yes.
And not to the selection process as such.
Yes.
Okay.
And another judgment. Madras नहीं तो कोई सुप्रीम कोर्ट ऑर्डर थे ना पूरा madras बना सब उधर हाँ सुप्रीम लाइव ला 2000 करोड़ स्टडी के लिए हाँ बस उधर
According to you, the decision to hold or not to hold preliminary examination is a matter pertaining to selection process.
Selection
But
process.
not to the eligibility and
Not the
qualification.
eligibility conditions.
He adds that the decision to hold or dispense with the preliminary examination, even when 1:5 ratio is exceeded, relates to selection process and does not go to the eligibility or qualification of the candidate, qualification prescribed for the selection process, and therefore is permissible.
Yes.
That is in terms of the Tejprakash itself.
This Prakash, the
Because that
leading judgment, that is the constitution bench judgment, and other judgments are there.
Yeah.
My lord, here,
Yeah.
your lordship may kindly see the advertisement itself. Because in the advertisement, admittedly, there is no extant rules or statutory rules. But in the advertisement itself, your lordship may kindly come to page 14.
Yeah. Recruitment, appointment,
Recruitment, appointment and conditions of service shall be guided by School and Mass Education Department Resolution number such and such dated 39/2020.
and the rules.
Which I have shown to your lordships, and Orissa Staff Selection Commission Rules 1993 as amended. So far as Government Resolution dated 39/2024 is concerned, it also empowers the Commission to exercise the power of relaxation. Your lordship may kindly see that.
Para 10.
No, not para 10.
Huh?
Your lordship may kindly see the resolution. Your lord may kindly para 12.
That resolution is in where which is part of
30th September 2024, which has been referred to in that advertisement.
separately given. No, but that was part of the
affidavit. Part of the affidavit.
Even affidavit. Second affidavit.
Second affidavit, my lord, and actually by email.
Your lordship may kindly see. I cannot say the page number.
Page 10, internal page 10.
Internal
Page
page
10.
10. The last page of that.
Clarification.
Last page of
Whenever it
that
is considered necessary or expedient to so to do it.
public interest, the government in the Department of School and Mass Education, by order for reasons to be recorded in writing, in consultation
So that
with
government can do it, not selection.
yes, in consultation with the commission, relax. My lord, here the requisition was made by the government. My lord, so far as the procedure adopted by the staff selection commission is concerned, my lord, the government has also a role to play. Not
The
that,
government has taken that decision.
yes,
The government has not taken the decision. It is the commission which has taken.
my lord, my lord,
The government has taken the decision.
With respect to the preliminary examination, there is no.
No.
My lord, it is the decision of the government empowering us to take a call.
that is contemplated in the selection rules.
Preliminary examination or not?
My lord, that is also contemplated in the
Yes, sir.
93 rules.
That rule,
Para 10.
para number now, clause number 5, my lord, of that resolution.
Para number 5 of
Resolution.
Resolution.
government resolution.
Government resolution.
That it is the staff selection commission is to take a decision.
Selection not
to be regarding
will be
shortlisting.
made on the basis of performance of candidates in the competent exams conductable number of the may decide to shortlist, but you decided to shortlist.
Yes.
Yes. And my lord, the manner in which, my lord, we have indicated in the para number 4.
May decide to shortlist. That is not mandatory.
No, but once you decide
Yes.
to shortlist,
Yes.
that becomes mandatory.
Yes.
It is content.
Yes.
But it is his contention. But in case of any conflict, suppose my lord, the commission has taken a decision otherwise than which has been contemplated in this resolution, but the provision of resolution will prevail. Your lordship may kindly see Tej Prakash case again, para 60. Para 60.
In case of,
Well,
what is your proposition?
my proposition is, my lord, if there is a rules governing the field or executive instruction or any resolution relating to recruitment, that will govern the field and that will override the advertisement. My lord, may kindly see para 60. It is all.
That's true. That's very well established.
Yes. Para 62. Sorry, my lord, para 62.
No, that's well established. It was
Yes.
second year law. I knew that.
Yes.
In my second year examination
Yes.
of LLB, I knew that. Where is the new thing now?
My
The
lord.
question is not that. Anyway,
My lord, my submission before your lordships is,
yeah,
my lord, so far as the government resolution is concerned,
yes.
that is 30th September 2024, my lord, that is the basis for, my lord, issuing that advertisement. And in case of any conflict between the decision of the staff selection commission and that resolution, the resolution will prevail. Well, your lordship is absolutely correct. This is the preliminary. Well, I am just placing one paragraph of that Tej Prakash judgment.
Yes.
There can therefore be no doubt that there are no rules or rules are silent on the subject. Administrative instructions may be issued to supplement and fill in the gaps in the rules. In that event, administrative instruction would govern the field, provided they are not ultra-virus the provisions of the rules or the statute or the constitution. But where the rules expressly or impliedly cover the field, the recruiting body would have to be abide by the rules. Here, admittedly, there is no rules. And the government resolution is there, and they have followed that resolution. That resolution provides that it is the discretion of the staff selection commission how shortlisting is to be made. That is not mandatory. Of course, but the commission has taken a decision to conduct the preliminary examination for shortlisting, and that was dispensed with because of certain reasons.
That could have been dispensed with by the government. But power to relax is with the government. Yes.
Yes,
But power to relax is taken by the commission itself.
but
That's what he is contending.
but be that as it may, but so far as preliminary examination is concerned, but that is a selection procedure. So in that strictness, it cannot be adjusted.
Because of that five judgment.
Yes, yes, yes.
My lord, let me
Just only 1 minute.
Please, Rose.
You are for whom?
One another set of intervention. In the first case,
Yes.
what in respect of bilanguage examination, in this recruitment, a challenge the selection process of Hindi teachers. All the candidates are Hindi teachers. They have given the pedagogy subject in Hindi language But however, as for the advertisement, they have objected that why the question has not come in English. That is my contention, because all the Hindi teachers, they will teach in Hindi. And question was in Hindi, pedagogy. But when the question is not in English, they have challenged after getting the answer key that saw that they will fail in the examination. That's why they challenged the bilingual question.
They also participated in that test.
Participated. And examination given
After participation, when the key answer sheet was published,
they will teach Hindi.
they turned around and
But they are asked for the question in English.
What's your name?
Saubhagya Swain, yes, Swain.
Mr. Saubhagya Swain, appearing for the interview, another set of interviewer submits that the appointment sought was to the posts of Hindi teachers, and they had written the examination in Hindi itself. But now, after coming to know of their unsuccessful result, pursuant to publication of the
Answer key.
key answers, all of a sudden they have raised the issue of bilingual requirements, and therefore such a contention does not avail to them.
Only in pedagogy subject, that is 20 marks.
20 months.
Especially when the allocation of marks is only 20 as against 150.
as against 150, well, at 1 point only. Well, as so far as Hindi main examination is concerned, well, it consists of 150 marks, 130 marks for Hindi contents, and 20 marks for pedagogy and evaluation. You also may kindly see the syllabus. Now, the dispute is only confined to pedagogy and evaluation, that is relating to 20 marks. Well, my learned friend has rightly submitted before your lordships. If examination is, since they have committed a mistake by not printing the question paper in both in English and Hindi, if a face examination is held for only pedagogy and evaluation, we have no objection. Now what they say?
To be held for whom?
For all?
For all.
For all?
All in pedagogy.
For all?
Well, though we have issued the notice with respect to the,
Those who have exercised their option.
but if your lordship will have that opinion, well, it would certainly happen.
But their intention is that for the entire examination, that is for 150 marks, re-examination should be made. But so far as 130 marks is concerned, there is no violation, there is no infringement, there is no mistake committed by the commission.
Both are segregatorily
And your lordship may kindly see the syllabus. Don't take a question.
separately and 20 marks.
Your lordship may kindly see the syllabus. Your lordship should be more clear.
Yes, I have seen that.
No, my lord may kindly come to page 39.
39.
39. That my learned friend has given the syllabus. Your lordship may kindly see that.
39.
39. It starts from page 38. My lord may kindly see 39. Syllabus for pedagogy and evaluation, it contains 20 marks. It carries to 20 marks. This is for all subjects. And so far as Hindi contents, my lord, that is at page 53. My lord may kindly see page 53. Hindi, 130 marks for Hindi contents. There was no mistake so far as Hindi contents is concerned. So therefore the key answer sheet was published in respect of Hindi contents, that is relating to 130 marks. Since there was dispute relating to 20 marks for evaluation, that pedagogy and evaluation, well, that result was not published. That key answer sheet was not published. And what they are attempting to, they say that for the entire, for 150 marks, let the examination be held. Although they have participated in the selection process.
That need not be. At
Yes.
the most, it can be in respect of 20 marks.
20 marks.
Is your submission.
Yes. Then we have no grievance.
My lord,
For all.
Yes, for all.
my lord, my short reply.
That's your contention also.
My
yes.
question only without repeating what I have already submitted. may I be permitted before counsel for the petitioner will make a submission? Only one submission, madam. Madam, it's a question of prejudice, madam.
What prejudice is caused to them by which is your contention?
Yes, madam. Madam, as I have already pointed out,
Did you know when you wrote the examination, did you know that the preliminary examination is not held?
My
You
lord,
knew that.
preliminary examination is not held, we knew,
Yeah.
because when that preliminary examination will be held, that was beset with a condition fixed in the advertisement itself,
That's all. I understood.
which is,
I want to just
and your lordship, my lord, yesterday your lordship posed that question, my lord, my answer, my lord, I am just reiterating, my lord. My lord, the preliminary examination for others were held in the month of February. The decision was taken not to hold in respect of us. Immediately, the present petitioner made an application under RTI to know how many candidates were there, who had, how many valid candidatures were there as against the post of Hindi teacher. To that, they replied in the month of March that this information will not be provided till the examination process is completed, and the written examination was conducted in the month of May. And my lord, your lords may kindly see, since nobody was aware how much is the total number of valid applications, question of challenging their decisions wrong, my lord, that contention was completely misconceived. Reason being, unless we knew that these number of valid applications were 5 times the number of posts, question of this challenge could not have been made. So that the information came to us only when they filed an affidavit before lordships in this first case saying that there were 4493 the total valid applications as against 711. Now, my lord, one more thing, my lord.
No, you are not answering my point at all. You are jumping.
We didn't knew.
Why you did not know?
My lord, cancellation of preliminary examination was within our knowledge.
On being asked.
Yes, my lord. Cancellation was within our knowledge. This ground.
Learned counsel from the petitioner.
Notice was issued at 12:2.
Yes, that is what we are.
Petitioners knew about dispensing with the preliminary examinations. However, he adds that his clients had applied under
Annex 4.
RTI
Annex 4 on page 77.
and for Annex 4 on
On 5/3/2025,
5/3/2025
Commission intimated.
when you had applied
Well, application is 17/2.
on 17 to
12/2, the notice was published.
17 to 2025. The key answers having been
Key answers now. How many valid applications were received in Hindi teacher post? Because they decided not to hold the examination preliminary.
You could have challenged this.
Just a minute.
You could have challenged.
Just a minute, sir. Well, on 12/2, they published the notice.
we should never agitate it.
Yes.
We should silence the
Why is saying his reaction?
My lord,
lawyers how they used to.
my lord, kindly see.
Yeah.
On 12/2, the notice was published that no preliminary examination will be conducted for the Hindi teacher post. Advertisement said, where there is 5 times the number of
You have said that and we all know that.
So naturally, we were giving the impression as if there are not 5 times the number of the valid applications to the number of vacancy. To know,
You came to know it only subsequently. That's your case.
yes, when we applied to get that information through RTI, they say will not provide.
Counsel submits that if clients were under the impression that the decision to dispense with the preliminary examination was taken because of the ratio being
Yes,
below the prescribed limit.
yes.
First, however,
We applied for RTI
subsequently they had applied under RTI
on 17/2, 5 days after only.
into
Only 5 days after the notice.
5 days after
The notice was published not to hold the preliminary examination.
the notice dated
12/2
12/2/2025
was published.
dispensing with the holding of preliminary examination was issued.
Yes, to which they replied on 5/3.
the commission replied on 5/3/2025 that they would not
Disclose this information till the entire process is over.
till after the recruitment.
Entire recruitment process is over. Completion of the recruitment process. That is what the language used in page 77.
Therefore, the contention that the petitioners participated in the examination, in the recruitment process,
Which was held on 15/5/2025.
5/2025. Come on. Cannot go against the petitioners in the case.
Exactly.
That's your contention.
Yes, ma'am. And your lords may kindly come to one reply to them. My lord, with regard to para 14 of the counter affidavit,
With the lordship's permission, before giving a reply to my submission, my lord, may I add one more sentence, my lord, because I took a liberty.
Yes, then you will reply that.
My lord, my submission, my lord, with respect to that prejudice.
One thing I should appreciate, though they are disturbed, you are not disturbed at all. You are very firm in your stand. This is our stand. I appreciate that. You don't get perturbed at all. Very smilingly you argue, even if they raise their voice.
Sir,
Anyway, that's
my lord, my
appreciated.
submission, my lord. The figures are before your lordship, as it is already indicated. So it's a question of preliminary examination to shortlist. So in that case, my lord, the maximum probability for the petitioner, had there been a preliminary examination, my lord, that he could have been succeeded and he could have been recommended for the examination, my lord. In this case, my lord, he has not been prejudiced. He has also been allowed to participate.
No, what he
No,
says.
my lord, I'm conscious, my lord. I'm just coming to that. Oh, sorry, my lord, because I interpreted the passages verse. My submission, my lord, that some other persons also, they came into picture
Yes.
at the time of competition, my lord, in the main examination. Well, now, at these particular steps, it is to be weighed by your lordship that the difficulty for the commission vis-a-vis the petitioner, whether he has been prejudiced, and the difficulty of the commission, my lord, in respect of all the categories. For each category, my lord, because we had to recommend 1:5, we did not have the persons. My millimeter submission, in addition to my submission.
And also there are two petitioners.
my lord, I have.
So that balance is to be taken into
Between these two.
consideration. Yes, between the two.
My lord,
Because he is a person who has not been disallowed to
Right.
participate.
Anyway, he is permitted to
He has
participate.
been permitted to, along with others. Along with others.
Because of your mistake, I am made to swim with many other competitors.
exactly.
Which otherwise I would have not been called upon to do.
But in this particular case, my lord, our submission, but it is not a mistake, because the figure says that there were no 5 types of the persons in the different categories, and there cannot be, as I have already stated, my lord, it is it amount to repetition, that it cannot be with respect to a particular SCBC category, a preliminary examination can be held. My lord, it is on the basis of the facts and figures, my lord, that it is just by a process, my lord, that he is a person, he is belonging to SCBC category, and the category number of the SCBC candidates are more than 5 times. But in respect of the other categories, well, it is not there.
But there are 4 petitioners.
The senior panel counsel of investigation submits, when Weekly submits, that the writ court should look into not only the infraction of the norms may be enacted in the rules or in the recruitment notification, but the actual prejudice suffered by the candidate who was permitted to participate in the proceedings in a wholesale way. Even otherwise, individual prejudice, as between individual prejudice and prejudice to the public interest, which the commission advocates, the latter should be kept in view. he adds that no prejudice whatsoever is caused to petition at all. Merely because the geological situation arguably has not been reduced by adopting a preliminary examination. That's your stance.
My lord, my reply, my lord. Prejudice has been caused, and how it has been caused, I will now demonstrate before Lordship. Your Lords may kindly see para 14 of their first counter reply. There they have given a category-wise breakup of the candidates to justify their decision. Your Lords may kindly mark. I am confined to Hindi teacher. Since we are concerned with Hindi teacher, we are not concerned about other category. Your Lords may kindly see yours, ACBC, SC and ST. And the total number of advertised vacancy you are seeing, number of valid applications you are seeing. Your Lordship is seeing, my lord. Now, my lord, your Lordship may kindly see, kindly come to this observation of the Honorable Apex Court in para 4 in the Constitutional Bench judgment of R.K. Saural. Para 4 I have outlined, your Lords may kindly mark. And then kindly see whether this affidavit is correct in law or it is misconceived. Your Lords may kindly see this paragraph. Because the entire UR post is available even for a ST candidate to be considered, SC candidate to be considered. You cannot bring it like this. Thereby you are compartmentalizing reservation which is not permissible. A UR category candidate cannot be considered against the reserve category post, but reserve category candidates can very well be considered. So while calculating it, how can you compartmentalize this same and decide whether it is 5 times or not?
Sabharwal, why that R.K. Sabharwal?
Yes, R.K. Sabharwal.
How that comes to be?
My lord, here, my lord, your Lords may kindly.
Sabharwal says,
Yes.
in respect of unreserved category, reserved candidate can compete. In respect of reserved category, unreserved candidate cannot compete.
Now your Lords may kindly come to this table. Para 14. In order to justify this, they say less than 5 times they have taken only your category candidates to calculate this. Whereas all the candidates in the fray are required to be considered for your category posts. And your Lords may kindly mark. Again, my lord, I will take your Lordships to that stipulation in para 4. Para 4 says, your Lords may kindly come to, on my request, your Lords may,
not his ground.
just a minute, please. Page 24. Page 24. My lord may kindly come to page 24. This is my last endeavor before Lordships to harp upon. My lord, this may sounds to be a reiteration. Your Lords may kindly come to the very plan of examination as prescribed.
Plan and pattern of examination.
Yes, my lord.
Yes.
My learned senior said, my learned friend appearing for the commission said, the entire words, the 3 sentences are to be used conjunctively. It should not be read in a.
He said it is not a rule. It is only one remark. Therefore, it should be interpreted with common parlance, not like a statute.
No. He says all the 3 sentences are to be read
harmoniously
in tandem. In tandem. Your Lords may kindly see this submission is misconceived. Reason being, the first line itself says regarding preliminary examination, and the second line says based on the marks obtained in the preliminary examination.
It is a stage-wise.
Stage-wise. So this is one
question of a harmonious construction will not
arise. Obliged. My lord, now your Lords may kindly see the real catch. It says, my lord, based on the marks obtained in the preliminary examination, approximately 5 times the number of candidates will be shortlisted post-wise and category-wise. Here, my lord, your Lords may kindly see what should have been the position. My lord, had this second line been interpreted correctly and adopted, then the situation would have been as against. Now your Lords may kindly come to the very same paragraph 14 where the table. The table. As against SCVC candidate 40 total advertised vacancy 80,
Total candidate who would have been participated in the written test is only 400. Instead, how many have appeared? 2943. Your Lordship may kindly see. This itself prejudiced and violates the condition of the advertisement once again. This power they do not have. Moreover, your Lordship may kindly see, I am deeply obliged because your Lordship have repeatedly posed that question. My Lord, the very same the resolution of the government only empowers the commission that 94, that resolution today given in course of additional affidavit, that only empowers the commission to adopt shortlisting. That power itself was utilized by the commission or exercised by the commission prior to issuance of the advertisement itself. And once that advertisement was issued and a detailed procedure has been delineated thereby, question of further relaxation, even if available under the rules, doesn't arise. Because that is a stage which has already gone. And your Lords may kindly see the prejudice clause they are saying, and they are saying on us, there was a duty to send up 5 times the number of candidates in each category. Let us suppose in a given case, there will be no candidate who had applied. Where from the commission will get? Suppose in a situation, my Lord, I am giving an example to myself subject to your Lordship's acceptance. Let us in the preliminary examination, out of 4,493 candidates who would have been allowed to appear at the written preliminary examination, only 300 would have qualified because the examination is qualifying in nature. Your Lordship have seen the examination of preliminary is qualifying in nature. Only 300 candidates belonging to SC, the few SC, few ST, few SCBC and a few UR category candidates who would have qualified. Where from the commission of they say as if a duty is cast upon them to collect these 5 times of the number of advertised vacancy to send up for the written test. Where from that? Because of that is why the preliminary examination. The persons who your Lords, my learned senior showed the syllabus relating to pedagogy. My learned senior had not shown the syllabus which has been prescribed relating to that preliminary examination in the advertisement itself. The advertisement itself, page 25, has prescribed the syllabus for preliminary examination. Your Lords may kindly see.
Go to 20.
Page 25.
You can go on turning the pages for another 5 minutes.
No, my Lord. Sorry. My Lord may kindly see. Page 25. Indicative syllabus for preliminary examination. General studies, arithmetic, logical reasoning, computer, internet awareness, current events. So, cunningly for Hindi teachers post, while holding this examination for TGT, Arts, Science and other some of the teachers, if they ignored it, reason being, your Lords knows my Lord, what would be the fate of these people. So they have avoided this. In order to avoid this, they have decided these few categories of people who will not appear at the preliminary examination. My Lord, now one thing they say, we have taken a conscious decision or uniform decision in respect of 5 posts. Though we have held the examination in respect of
Other 4.
The question is, those persons are not vigilant. Can a wrong make another it? When I'm vigilant, I am Hindi teacher category post. I am abreast of my right. I am before your Lordships, and this Honorable Court has protected the entire selection process from being culminated into any result. But question of all these things, we have followed a uniform policy. Certainly should not stand on the way. The reason being, you have done wrong. They have not challenged. The selection process you have completed. Well and good.
That they have not come to court, you have come to court.
Yes, actually, in my case, I have to be considered. My humble submission before Lordships, the Tej Pathak case, my Lord, my learned senior has said only the conclusion part. My learned senior said it is only in case of eligibility, but
qualification and eligibility, but in respect of mode of examination, mode of recruitment, this is continued.
He says that eligibility, the rule of game principle will apply only in case of eligibility,
And qualification.
not in case of procedure. You must make kindly the conclusion. I have not.
In the same judgment.
Same judgment.
One second, I'll read that way.
Then your lordship,
He read para 54, 55, 56 para.
it is para 50. Well, at 4 to 59. I have this. So just kindly, it will be easier on your lordship's part to just see it, because I don't want to kill your lordship's time.
I have already quit.
He has argued well. He has argued. For any joke, for humor, you can take that step.
My lord, may kindly see this. I have just marked for your lordship's.
No, which paragraph? You tell me, I am holding that judgment. Huh?
Yes, this is from Manupatra. That is why I am pointing out. This is from Manupatra.
How the sentence begins?
Yes, my lord. Conclusion. It's a conclusion.
Yes, here, 65.
My lord, for
Answer the reference.
Yes.
Kindly give it to him.
my lord,
I
may,
don't want to get confused with other
yes, yes. Your lords may kindly see the conclusion.
eligibility criteria.
My lord, 4.5.
5. They change.
Recruiting bodies. My lord, it starts with
Recruiting bodies.
recruiting bodies, subject to extant rule, may devise appropriate procedure for bringing the recruitment process to its logical
End.
and provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and a rational nexus to the object sought to be achieved. So the procedure is there. Second, my lord, the extant rules having statutory force are binding on the recruiting body, both in terms of procedure and eligibility. So my lord,
There is rules.
so my lord senior is wrong in saying that the Honorable Supreme Court has not dealt with the procedure, because the more is that if the lordship
Next sentence you did not read.
Yes,
Yes.
65.5.
placement of the select list gives
No, extent rules.
However, where the rules are
Yes, yes.
non-existent,
Yes, non-existent or silent, administrative instructions may fill the gap. Here, my lord, there is an administrative instruction which authorizes the commission only to shortlist, not to relax any procedure after it is prescribed in the advertisement. There lies the distinction between the two. Once you have utilized that to prescribe the procedure in the advertisement itself, you are bound to follow it meticulously till the end. Question of its violation, relaxation, when such a provision is not available in the advertisement itself, is not permissible.
Well, my lord, only one clarification.
Just a minute.
my senior used to say,
Yes, sir, look,
once I asked him, sir, how long I should argue before the judge? He said, till cows come back.
Sir, gotte line. Sir, you're also only one line. In the tentative merit list, the tentative result which they are showing, you lots may kindly mark. There is a catch. You also will find that tentative result, whatever was answer key was published, that was not final. You lots may kindly see from
It is relating to 130.
130.
130.
You also kindly mark the top. Here it has been mentioned that it is only the answer key itself is tentative, it is not final.
So
Just a minute.
But the answer key,
That is not final.
the answer key, he knows about his position.
Second thing,
That he will not be successful. Therefore, he turned around and filed this written.
this is I don't second thing is
Yeah.
there might the notice itself gives option to candidates whether to opt for it or not. Not the answer key which has been provided is final for all purposes. That also commission is not saying. So these interveners who do not have late to stand because there is no list prepared, no they are favor. They are saying we are stopped because it has been published. So that the list itself being tentative, it has got no binding and it is variable from the very notification itself. That is what my submission is.
Very.
Oh.
All argued very well.
My lord.
Yeah.
May I mention? My lord.